Good morning and welcome to today's webinar with Softwerx. My name is Lindsay and I'm going to be comparing today's webinar. I'd like to advise you that today's webinar is being recorded and you will receive a copy to refer back to and share with work colleagues. I'm joined today by three experts. Adrian Becker, Technical Director of Softwerx. Adrian has been at the coalface of GDPR compliance for a while now and will bring a real practical insight to the subject. Good morning, Adrian.
Good morning, everyone.
We're also joined by David Smart, who's MD of Softwerx. Softwerx hold a number of individual GDPR qualifications and been helping lots of businesses and organisations understand GDPR in the last 12 months. Good morning, David.
Good morning, everybody.
And finally, but no means least, Veronica Hartley, who is heads up our RIAA Barker Gallett's company commercial team in London, and she also advises on a variety of businesses across a range of sectors, including construction, fashion, financial services, marketing, media, mining, publishing, and real estate, to name but a few. Good morning, Veronica.
Good morning.
So GDPR comes into force May 2018, so not long at all. And there's lots of practical steps we're going to be discussing today from a compliance issue. We're also going to focus on the practically addressing three of the more challenging areas of GDPR: lawfulness of processing, security of processing, and rights of the data security. If you're already up to speed on the GDPR in terms of what that means for you, but your business, and you want to know more, then hopefully this session will be useful for you. We will take questions at the end. If you do have any questions, don't think you have to wait until the end. Please just use the chat box on the right-hand side and start to put your questions in, and I'll facilitate those at the end of today's session. So let's start our GDPR journey today. Over to you, David.
Okay, good morning, everybody. Thank you for joining, especially those that are joining us for a second time, having already attended our previous webinar, Understanding GDPR. My name is David Smart, I'm the Managing Director at Softwerx. Before we get started, it's probably worth touching on why or how we became involved with GDPR. Apart from GDPR being intrinsically linked to cybersecurity, and as an IT company, we hold and process data on behalf of a lot of our clients. We realised around 12 months ago that GDPR was going to affect our business in a big way. So first of all, we'd better understand it for our own benefit. 12 months forwards, and we've undertaken a number of GDPR qualifications. We've helped a lot of our customers both better understand and become better prepared for GDPR, and of course we've helped ourselves along the way. Our approach or attitude toward the General Data Protection Regulation in general is that we think it's a very good and long overdue regulation. I should admit that we didn't always think this positively about it, but the more we found out and the more we got involved, the more it makes sense. Indeed, for any business in the modern world, that the integrity of data really needs to be, and you'll hear this phrase a lot, not just from me, integrity of data really needs to be at the heart of the organization. It can no longer just be a bolt-on or an add-on. Okay, so just to cover off this agenda that we have here, I think I said this last time. I should apologise in advance for the sort of volume of information today. I think sometimes we always try and bite off more than we can chew. We have a relatively small amount of time, and what we thought we'd focus on are the key issues that most businesses that we speak to seem to be concerned about, and perhaps some that they're not aware of and they're not concerned about, but they should be. So what we've got here are the questions that we tend to hear the most. I'm not going to read them all out verbatim, but generally they kind of cover the areas around GDPR from a practical perspective. So if we start with the first one, what do we actually mean by compliance? The first sort of piece of good news here, or possibly not so good news, is that from a GDPR perspective, you can't actually be formally compliant in terms of receiving some kind of certification like you would do for a number of other compliance programs. In fact, within GDPR, Article 57 talks about drawing up the codes of conduct, encourages the establishment of data protection certification mechanisms by local member states. There are no formal compliance certifications for GDPR yet. Likely that these will emerge within the UK in 2018. Probably out of, if I pick ISO 27001, would be a very good start. Another certification or program to be aware of is the British Standards Institute, or PIMS 1012, which is closest, I guess, to GDPR. But again, please note this is not a GDPR certification, but it would help demonstrate good practice towards compliance. So our advice, practical advice around compliance is you still need to do everything you can toward a state of compliance. The next question that we tend to get quite a lot of is around Brexit and will GDPR still apply? For a while, the government has been stating it largely will apply, and by this they mean that when the UK government publish their own data protection bill, it will look quite similar to GDPR. The full copy is now, the data protection bill was published just a couple of weeks ago. The full copy is now in the public domain. We've included a link to this at the end of the presentation, so you can go and read it yourselves. There are just a handful of differences, and we've summarized these very briefly on the left, or perhaps better described as member state derogations. But in short, GDPR will in effect be law within May 2018. And when, or dare I say if, there is a hard or final conclusion to Brexit, then data protection will be law, and it is almost identical to GDPR. The next questions that we tend to hear kind of revolve around how much, how quick, the least we need to do. Of course, the answer to these questions is very much dependent upon the size and nature of your business. We would advise two things here. One, if you don't have a line item in your budget for data integrity management, cyber security, going forward, you should really plan to have one. And two, perhaps more importantly, and in a sort of wider answer to these questions, we'll touch on this again later. Data integrity management protection just can't be an add-on or a box to tick or a burden to get through anymore. Data protection really needs to be at the heart of the organization and not something that you just try and get through quite quickly. So moving on to the sort of final question really and the guts of the webinar, what practically should you be doing next? The first thing really to ask yourselves or determine is where you are on the journey towards GDPR compliance. And this red, amber, green style matrix may help your thinking. Most organizations that we talk to are somewhere kind of between grey and orange. Of course, time rolls forward, the state of readiness or alert will become greater. The questions really in trying to position yourself in this matrix or understand of where you are, the questions you need to ask yourself are and this is perhaps not a full list, but with what comes to mind really is do you know what data you have or what data your business has? Do you know where it is in the world? Do you know where it came from, how it was initially acquired? Do you know why you have it? Do you know what you do with it, how you process it? Do you know who's involved with that data? Who's in your supply chain? Who are the controllers and who are the processors? I think only if you can answer all of these questions categorically and be able to evidence them, then you can only then really put yourself squarely in the green box, or maybe between grey and green. One important thing to remember here as well that some people aren't aware of is that GDPR, the General Data Protection Regulation, also applies to all hard copy paper records as well as online. GDPR is not about just online data, it's about all data. So if you have a warehouse full of hard copy information, that also needs to be audited prior to next May. So the next thing to ask yourself, I guess, is who needs to be involved with a GDPR compliance program. And we always like to state here, even though we're an IT company, GDPR compliance is not all about IT. It's not all about technology. Invariably, a comprehensive GDPR program will be a kind of parallel program which needs to involve a number of primary or key stakeholders. So here we have some of the key stakeholders, and what I've detailed below at a high level is some of the tasks that these stakeholders would be involved with. I guess the first point to mention, if you don't already have a board level awareness, ownership, sponsorship, backing, support, you're probably going to have an uphill struggle. You need to get that to start with. It's also a good idea to determine at the outset whether your organization needs something called a DPO, which is a data protection officer, because if you do, now would be a good time to appoint or arrange that. Everything really then starts with a gap analysis, and we'll talk about this some more later, but the biggest single area of risk in terms of a fine is really around something called the security of processing. We talk about this later as well. So you need to understand how your business would score in terms of its cyber posture. The legal work required around your terms and conditions, in particular with your contracts that you have around your supply chain, and this really relates to the controller and processor relationship. These will also be very significant. The main tool or task in terms of understanding your data, and by this I guess I mean being able to answer the questions I just asked about your data in the previous slide, is what's commonly known as a DPIA, or a data protection impact analysis. And if you don't have this, or you haven't started this exercise, then I'd probably suggest that you haven't really started your GDPR compliance project or program. Just as an example of, I guess, what a data protection impact looks like, or as a top level from a strategic approach. Here we have a view as to really be able to prioritize your approach. It's quite a simple kind of matrix. What we found, that there are many organizations that have quite a lot of unstructured data, which is also personal. This means it's in the top right corner. It's phase one, and it should be your primary concern in trying to understand what you have. Okay, the next area really, or at this junction, it might be worth reviewing again, if you haven't already, to what extent you feel you have the necessary resources or skills in-house or in place. When I consider our own business, and we went through this exercise, we certainly didn't have all of these skills and resources in place, particularly around legal, for example. What I've got then really is a kind of final to-do list, I guess, for want of a better term. It's not meant to be in strict order. In fact, not just because we're an IT company, but because it's the most likely reason you're going to get fined, we'd probably suggest that you sort your cyber posture as a primary action. But either way, really, whether you juggle this order around in your own business, these are the next practical, the first practical steps you need to be doing towards a GDPR compliance program. And that kind of group of slides there really summarizes compliance from a general perspective. One other area that we want to talk about, we hear a lot about, is marketing under GDPR. We want to talk about this for two reasons, really. One, because it's important for most businesses or organizations, because I guess almost all businesses and organisations need to market their products and services at some point. There's also, under GDPR, that seems to be causing quite a lot of confusion and concern, particularly around how you might initially make contact with a prospect if you haven't yet got consent. And I've heard this described by some as a kind of chicken and egg scenario. For the uninitiated, the new and in fact current regulations around marketing under GDPR and PECA, which is Privacy Electronics Communication Regulation, can be confusing in that there is more than one regulation at play here, and the nuances between the regulations are not always overtly clear. So just to cover off very quickly the background to the regulations, and I'll try not to hover on this sort of too long, but there is, of course, the GDPR that comes into force, into law in May 2018. Before then and now, we have the current Data Protection Act, recently announced, which we've just touched on previously. Post-Brexit GDPR, we have the UK Data Protection Bill. On top of this, and for the marketeers, we have PECA, which is the Privacy Electronic Communications Regulation. And just to make things exciting, at some point next year, in conjunction with GDPR, PECA will be replaced by something called the e-privacy regulation. So all of this, for example, if you're talking about something as simple as consent, can start to become confusing, as consent has a meaning under PECA as well as GDPR. And it's not a mistake, by the way, that these two regulations and soon to be the e-privacy regulation are intrinsically linked. So all of this can be a minefield, and we could probably do a separate webinar on marketing under GDPR alone. But today I just want to touch on two, I guess, important pieces of practical advice that we've learned and we'd like to pass on. The first is around processing of data in a lawful manner. And this is described in Article 6 within the regulation Lawfulness of Processing and Related Conditions of Consent, Article 7. Now, a high level here, we would just advise strongly, I mean, there's 6 options relating to lawfulness of processing, and only one of these is consent. We would advise marketeers quite strongly to investigate the feasibility of using the last reason, which is legitimate interests. As I say, we don't have a lot of time to cover this here, but the Direct Marketing Association, and we have the links to all of these resources that were mentioned at the end of the presentation, have done a very good job of adding clarity to this area through an ongoing dialogue they have with the ICO, the Information Commissioner's Office. The second piece of advice that we'd like to give to anybody really considering GDPR is around something called repermissioning. I've also heard it called up substituting. Quite get my head around that. But what I'd like to just run through is a couple of quick examples. One of them being Honda, who's fined by the ICO recently. It was only a fine imposed was £13,000. So for Honda, I guess it wasn't too much. But it's the nature of the background of the case that had many concerned or confused. The Honda enforcement notice with the ICO is public domain. It can be read online. It's quite lengthy, but in summary, Honda, arguably with the best intentions, were simply trying to get their house in order prior to GDPR. Now, the ICO are very clear about getting your house in order and repermissioning, principally for one reason. You should not be repermissioning for one reason, and that's because you should have had permission in the first place. And under the guise of the ICO, it's a nonsensical or in fact, illegal activity. Honda were, I guess, relatively lucky at £13,000, or put another way, the ICO deemed that they were at least trying to act in good faith. However, where Honda fell foul was not actually under GDPR guidelines or even the current Data Protection Act. Rather, they fell foul of consent rules within PECA. In particular, Honda sent out 300,000 clarification emails to their customer base about their marketing preferences. However, they took their data from their own base, which they acknowledged they weren't sure where all of that came from, whether it was permissioned and collected properly in the first place with regard to opt-in, opt-out, etc. Another quick example here were a company called Flybe, who did more or less a similar thing, but they sent out 3.3 million emails to their entire base, asking a simple question of, are your details correct? They were fined £70,000 for this activity. The problem is, or was, that their data was also not correctly collected or permissioned properly in the first place. It was a mixture of known, unknown, opted in, out, not sure, etc. And this goes back to the ultimate question I asked at the beginning: do you know what data you have, and do you know where it came from? So while Honda and maybe Flybe might have been trying to do the right thing, they contravene not GDPR but PECA rules. So we would just, be really strong in terms of this sort of practical advice. Avoid even thinking about repermissioning your database. And just recently, to really kind of make the point, Wetherspoons, pub leisure chain, just a couple of months ago, I think in July, actually announced that it has deleted its entire database of 700,000 individuals because they're not sure how they got all of that information. Now, their decision was possibly influenced by the fact that they were also hacked a couple of years ago in 2015. But I guess our point would be that deleting, or at least pruning your database maybe shouldn't be something that you disregard totally out of hand. So that covers the marketing piece. What I'd like to go on to now is just around security of processing, and here I'm going to hand over to Adrian Becker, our technical director.
Thank you very much, David. So I think one of the things we're going to ask is, what will most likely shut down your business? Or actually, let's start further up. Why would you be fined by the OCO, or what will trigger a fine? If we say inadequate privacy statement on your website, it's unlikely. You will need to fix it, but it's unlikely that you'll be fined. Possibly being requested that you had a failed subject access request. Again, the fining will be unlikely depending on how many you have failed in the past. However, you would most likely be instructed to comply with a subject access request. However, if you had a data security breach, it's highly possible and it's highly likely that you will be fined. If you look at that, the fact that most businesses have or are suffering or will suffer some sort of cyber attack or data breach, you just have to go to the BBC website to see that on a daily basis. And if you look at the fines that's been levied by the IOCO under the Data Current Protection Act, it relates to issues like data integrity or result of data being lost due to a cyber breach. So how bad can it really be moving forward? Well, under the current Data Protection Act, a maximum fine of £500,000, and to be honest, it hasn't really been levied. I think TalkTalk was the closest at £400,000 to date. Moving forward, that obviously changed significantly, as these fines will increase to 4% of worldwide turnover, or 20 million euros, whichever number is bigger, and that's a significant. However, again, I think there will be a lot of interim steps before such a large fine be issued. In our view, all organizations obviously want to avoid a fine or limit the fine that they receive, but what you really want to avoid moving forward is something that will damage your business terminally, e.g. the fact that if you do suffer a data breach, you need to notify the ICO within 3 days, and you also need to notify the data subjects that their data is breached. Hence, all of the breach information becomes available in public, and probably cause you a significant challenge from a business reputation. I think Equifax at the moment, if you just go online, have a look, they are suffering significant challenges in the US and the UK due to the data breach of losing 135 million records, which currently has cost the CEO to step down, and there will be a few more casualties along the line. So what's important here is, how do we actually dodge the bullet, as they would say? Again, I'm going to use the terms like embrace the changes you need to make, rather than do the least you need to do. And what we are talking around here is essentially Articles 31, 32, and 33 within the GDPR. Here, the regulation very clearly provides you with an option whereby you do not need to inform the ICO or the data subjects if you have already taken appropriate technical and organizational protection measures. Some of the examples they would give for you is encryption. Have you encrypted your laptops? Have you encrypted your mobile device that's been stolen with sensitive information on? You've taken appropriate action. Some of our customers have also asked what the regulation means by organizational protection measures. Based on enforcements undertaken by the ICO, this would mean things like security training for your users. How have you trained them not to automatically click? Do they understand what they should be doing while they're browsing online? The ICO has also published a best practice guide towards a positive cybersecurity posture. And what you can also look at is Cyber Essentials or Cyber Essentials Plus. Whichever route you take, our very strong advice for you is to really review your cyber posture and ensure you have a strong posture moving forward. Finally, if we look again, we just want to go back task of the DPIA, because the first step, as David mentioned earlier, is to do a data impact analysis and understand the data you have. Part of that as well would be, how do I find out what data I have? How do I know that? How do I respond to a data subject request moving forward, as it will become a significant part of GDPR moving forward, and users will also become more aware of their rights, because I think that's the one thing that people weren't aware of. Currently, you can do it, have a data subject request. However, moving forward, this will be advertised in much more details. So before you can start and actually effectively work out what you're going to do for yourself under GDPR and address your data subject requests, you need to understand what data you hold, structured or unstructured, and where that data is located. In a practical sense, you have two options to undertake this task. You can manually undertake it, physically searching through every file and folder to see if an individual's name appear or what data you hold on them, or employ technology. From our point of view, we, as from a group's perspective, have implemented XNR, which is exciting new technology for us, because what it helped us to do is analyze all of the data in our unstructured folders. That will include users' home directories, it will include file shares, and analyze the data for information like ethnicity, national insurance numbers, home address, and provide us with a quick way of viewing that information. And I'm going to use a practical example on myself. I assisted a customer a few years ago with sorting out an Excel spreadsheet that had a lot of sensitive information in, stored it somewhere in my home directory, and forgot about it. Once we implemented XNR, it's actually highlighted it. I've got a file with significant personal information in it, and it hasn't been touched for 5 years. I managed to get rid of it, slightly embarrassing, but it's very easy to happen because, let's face it, nobody can really remember every piece of data where they've stored, and you cannot guarantee what any of your end users has potentially done in the past. So with that, what I will do now is, if you want more information, just reach out to myself. I can give you a lot more information, but I'm going to hand over to Lindsay now.
Thank you, Adrian. Thank you, David. Lots of useful insight there, as always. Veronica, is there anything you would like to add in addition to the points that David and Adrian's had, if you wish?
Well, it's just generally that from a legal point of view, it's it is going to have a significant impact, but I think Ms. Denham has been clear that if you're trying to comply with GDPR, that's going to go a good way to protecting you, and we're here to be able to help in terms of deciphering what's meant. But there is a wealth of information on the Information Commissioner's website, and so I think it's a really good place for businesses to start. And yes, I think thank you very much to Adrian and David for the really helpful guidance.
Lovely, thank you, Veronica. We've shared on the screen a load of useful links for you. The latest message from Elizabeth Denham, the data protection self-assessment tool, GDPR information from Softwerx, links to the DMA, which obviously you'll get after all of this presentation. We've had lots of great questions coming in, which I'll just start now, if that's okay. What do you mean by data? I think Adrian touched on it before, but in terms of data, do you just mean employee data? You touched on like national insurance, or do you mean employee data? Can you just clarify what you mean by that, please?
Any data that includes data subjects information, and there's a list of information that is classed what is data and what is covered under GDPR. And what I have been clarifying to organizations, GDPR doesn't really cover your P&L, for example, or information you send on a daily basis to individuals. But what it really covers is what information you are holding on data subjects, any personal data. And what I'll do is I'll ask David just quickly to read the official response from under the GDPR law.
Yeah, I'm the boring guy. We had this question last time actually, and it was around, well, is it B2B, is it C2B, is it email, what does it mean? This is all public domain, but I'll try and make this very quick. Personal data means any information relating to an identified or identifiable natural person, otherwise known as a data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier, such as a name, an identification number, location, data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. It's pretty comprehensive. So there are probably not many aspects of data relating to an individual that are not covered by GDPR.
Yeah. Okay. I think that's useful.
Can I just add a legal development in this area?
Of course, yeah.
Essentially, also previously, people were able to say where some data didn't count as personal data because on its own it couldn't identify someone. So, for example, an IP address. But it seems that now case law already had extended this, but in fact GDPR is doing it explicitly as well, is that where something like an IP address, although on its own it can't identify someone, if with data held by somebody else it can, then it will come under personal data. So it is incredibly broad.
Yeah, lovely. Okay. Another question, and David touched on this earlier. If companies are to avoid repositioning or whatever the other option was that someone was using content-wise, what would you suggest if people have got a database already with data? What would be your suggestions of either sort of the top things to look at or how to make a decision with what to do with that data?
Right. Okay. There's a very quick option and there's a slightly longer option. The quick option is if, let's assume you've got 25,000 records and I don't know, 1,500 are known active customers, you know, where you got that data and you deal with it. They're fine. If you don't know if over a number of years you've acquired your other 25,000 records by purchasing data or events, or not sure whether you opted in, opted out, and this is more to do with PECA than GDPR. If you're not sure, you shouldn't discount the idea of really starting again, as radical as that sounds, because if you don't do that, and this is really from a kind of marketing point of view, so where you've got data that is part of a contract with a customer that you're servicing is different to prospect data within CRM, customer relationship management system. But your starting point for all of this must be a data protection impact assessment. And of course, it's not all about marketing. It's not all about CRM. It's all about all of your data and all of your data through your supply chain. So, you know, the single simple, best and only place to start is a data protection impact assessment.
Okay. You also touched on the paper versions of data earlier. A few people have asked, obviously you touched on XNR, and a few people have asked more about XNR, which I'll come on to in a moment. But with regards to paper data, so if there's lots of companies out there, they store their paper data, including the NHS, I think. There's systems near us where they store their paper data in a big warehouse. Is there any, there might not be an easy answer to this, but we're just being asked.
There is. There is. It's not one that people will want to hear, but there is an easy answer.
Because obviously XNR wouldn't be able to help with that because it's paper data. It can't physically go and look. How would you advise people to deal with paper data?
I'd get it online, whether you want to keep the hard copy as well. If you need to audit it, you need to keep it online, unless you're going to keep an army of Oompa Loompas in your aircraft hangar full of paper. And we've had this a couple of times, and if, particularly with our own group company, for example, a lot of information is hard copy. GDPR covers all forms of data. It is not an online digital regulation. Now you will need to be able to evidence and audit that data. Now, if you've got the world's greatest filing system and so on and so forth from a manual perspective, well, okay, that's fine. Good luck. But if you haven't, and you've just got 7 years of data in a cellar or a lockup somewhere, this will need to be audited prior to May 2018. Otherwise, in fact, what you're admitting, as it were, that you don't know exactly what data you've got, and you've got no idea what's in there. So that's the answer. That is the actual answer that most people don't want to hear, but that's the fact of the matter.
I mean, yes, we're going through it actually personally as a law firm, going through all of those. You can imagine lawyers are not always the most advanced in terms of technology, and we are getting up to speed with the help of Softwerx. But one of the things we are doing is reviewing all of the hard copy data and scanning it all into systems. And in fact, because of the law under the GDPR in terms of minimization, so being obliged to keep information for as short a time as possible, but while complying with your legal obligations. Of course, all different types of data have different storage periods. So, for wills, it may be 12 years and so on and so forth. And so absolutely, to make the job a lot faster, the good news is for businesses, although it's a task that is a pain to do, the good news is that it actually makes those processes far easier in future. And we're finding that actually the costs hopefully actually come down, because hard copy storage and things like that cost quite a lot. And as you say, unless you've got teams of people to sift through documents, it's very expensive. So making everything electronic automates the process far more easily.
I'm glad you jumped in there, Veronica, because I didn't want to mention law firms, but we speak.
Well, we've got a lot of paper storage, and but it's great getting rid of it. It's a very cleansing feeling as well.
Yeah,
and I think GDPR is a good opportunity to do a lot of these things.
Yeah, I agree completely, and I'd go back to the almost the core or the heart of the. If you speak, or if you hear Elizabeth Denham speak, as a modern organisation, data integrity, protection management needs to be at the heart of your organisation. And once you've got your head around that, everything else kind of makes sense. If you can't settle your mind with that, everything is a burden and is a problem.
Yeah. And I guess it's not just from the legal point of view. I mean, I used to work in financial sector, so financial, they have to keep data for so long. And obviously, probably the biggest impact is going to be someone like the NHS, who are going to have to make sure they're going paperless, whether they like it or not now, which is going to be very
interesting. Well, I was just about to say I've got a great NHS anecdote. Actually, I'm not sure it was the NHS. I think it was in the States. But this is, for I guess from an individual point of view, where you're not overly concerned about your data or privacy individual. This was from Alan Calder, who's the CEO of IT Governance. So it's kind of not your normal urban myth, but this was a story around a chap who didn't feel very well and went to the hospital. He'd previously had cancer about 10 years ago, but was cured, as it were, in remission, and went to the hospital not feeling well. And they looked at his records. His records hadn't been updated, saw that he had cancer, and put him on a chemotherapy course, and he died. So, you know, not every single piece of data is a matter of life or death, but some of these stories, as it were, you know, there will be somebody in the world who it affects dramatically.
Yeah, yeah. And I think the point that Veronica's made, you know, actually it's a good reason to get your data all in, you know, control and understand it and know where it is and what it is, because, you know, God forbid if Veronica's archiving system, which I'm sure is very secure, did go up in flames, actually they then can't keep them wills for 12 years, which actually then puts your business in a much more vulnerable position. So that's interesting. Thank you. Can you tell us a little bit more about XNR, Arjun? Because a few people have asked to know a little bit more about it.
Yes, XNR is a technology designed really to quickly analyze a document, retrieve key information, and index it in a very quick and fast searchable format. So again, I can put a proper demonstration together for people who's interested. But what it really does is it crawls the network, it analyzes the data, and it indexes it, and then it can understand, for example, if you made an offer letter to somebody, it will work out there's a first name, last name, a home address, and a telephone number in there, and analyze that and go and find documents that are similar with that or have potential information regarding that, and go and present it in a quick dashboard in a single location for you, all documents that potentially have personal information in the system. So does it have a national insurance number, when last has that document's been touched, how many times that is actually exist on the network, so duplicate. So as an example data, XNR have pointed the technology at the Sony data breach. It's indexed all 300 gig that was published of personal information, and what this has done is it lets us, for example, if we had a data subject request come in, I can log into XNR, I can type in Adrian Becker, and it will bring back every single document where Adrian Becker appears within 3 seconds. And I can literally get a list of documents where it is, and I can then do a further investigation. Why is Adrian's name in there? Is it just a normal email? Which, fine, we can justify that it's not personal data. Although it belongs to a personal person, but the impact would be low, or actually it contains all of my date of birth, where my banking details, etc., etc. But what it does let you do is get a much better understanding of how much data you have, what type of data it is, what potential liabilities against the data, that security, and when last has it actually been accessed. And what we found to date is about 50% of all data on the network is duplicate, and about 70% to 80% hasn't been touched for 5 years.
Okay. Off the back of that, I have a question, if I may. In terms of data, we're all guilty of keeping things in our email inbox. So as an example, if I worked in HR and I had emails from people that had sent me CVs, would XNR scan my email box?
Yes, so we've got options. It will scan SharePoint, emails, it will extend into databases moving forward. It's really, where do you want to draw the line and data? And you've got to also understand where your email is being held. But yes, is the short answer. Longer answer is, depending on where you are, there's various tools that can combine to get the information together.
Okay. One last question. Thank you for all the questions today. They've been really, really good. If you have any last questions, feel free to put them through, but this is the last one I have. We've talked about data and deleting it. If we do delete it, do we need to keep a record that we've deleted it? Or can we just, like, if we've got, say, Arjun's on my system and I deleted it, is that good enough? Or do I need to keep a record somewhere that I've deleted this because of this reason?
I think the answer to that, and this would be along with the lines of sort of common sense and transparency. I don't think it would do any harm, but the fact that you haven't got it means you haven't got it.
Yeah.
So,
Okay.
yeah, I wouldn't say it's a necessary action to take. I mean, the simple thing is, and when we talk to a lot of organizations, we talk to our own group company and they say, well, we've got 4 terabytes and it's all essential, and well, actually a lot of it's duplicate, some of it isn't essential. The first thing we do is kind of go on a pruning exercise, because the best thing to do is to only have the data that you really need within your business.
Yeah,
absolutely.
And
But
from a legal,
moving, oh, sorry, Veronica.
no, that's what I was just going to say. From a legal perspective, I think, again, a lot of this comes down to having the right policies and procedures in place and being able to point to them. So if you've got, a policy for your business, and you can point to it and say, no, this has been deleted on the basis of the following policy that's in line with GDPR, for example, that's going to put you in good stead, and you won't need to have a specific record, because I think actually keeping a specific record of what's been deleted could potentially have you in breach effectively of actually deleting that information as required.
Mm.
Exactly, and there is systems that at least will record it, because you do have the right to be forgotten, and it has to be. You might need to demonstrate moving forward that you have actually executed the task. For example, I've run a right to be forgotten. I've deleted all Adrian Becker's email on our email system wherever my name appears, as an example, and there should be some sort of record that you have actually undertaken that action, because there's also, under the new data protection bill, it is going to be a criminal offence for altering records with the intent to prevent disclosure following a subject access request, and you could end up in a situation where a person knew you had data, or they do a data subject request, you then say, no, we don't have the data, and you don't, and it's not recorded that the person that was doing the exercise deleted the information.
I think, just to summarise that, Lindsay, I think the focus needs to be on the data that you've got, not the data you haven't got, and why you've got it, what you're doing with it, where is it, and importantly, your supply chain with that data. So even if you've got your act together, you need to determine whether you're acting as a controller or a processor or both, and who else is in the food chain.
Yeah. Okay. One last point. I think David and Arjun touched on it earlier, in terms of you need to get board buy-in, which isn't always necessarily going to be easy, because they might see it as a hurdle rather than an opportunity. But you ultimately need to get whole company buy-in, because Arjun touched on earlier in regards to user training from a security point of view, but ultimately your whole company needs to be bought in terms of, why are they putting this data on the system? Do they have permission? And all of that GDPR guidelines, really. Do you have any hints or tips on how that might be good to share with a company?
Yeah, I do have a tip, and it's a fresh tip that I picked up speaking to somebody yesterday. So Softwerx uses and recommends, in terms of security user training, program suite from a company called Know Before. We don't list all these things, but they're on our website. This is a company that I think is growing at 300% per quarter. It's not the only company out there doing comprehensive online security user training, but it's I think the global leader at the moment. Anyway, I was talking to their channel manager yesterday at an IP Expo event, and just in passing conversation around GDPR, she said to me that just this month, and I guess others will follow, but Know Before are releasing, as part of their security user training, end user training around GDPR and the importance of data as well, which is really excellent, because then that whole message gets out across your company to all at an individual level, as opposed to just staying in the sort of compliance managers, in the data protection officers in tray. Everybody's up to speed with the importance of data, and essentially, to sort of bang on with the cliche, really helps put data integrity at the heart of the organization. But that's a practical piece of advice I'd advise. Have a look at some software like that.
Yeah. Excellent. Okay. So just to finish today's webinar, thank you all very much for the people who put questions forward. If you do need any help from a legal perspective, then Veronica and her organisation can help you on that. If you need any help from a data, general GDPR guidance or cybersecurity point of view, then please feel free to get in touch with Softwerx. But thank you very much to our speakers, Arjun, David and Veronica today. And thank you to you for attending. We will be sending this webinar recording through to you, so you can refer back to it and also share it with your colleagues within your organisation if you wish. Please do keep an eye out for your emails and social media channels, Twitter and LinkedIn, for other great webinars we have coming up in the future. But on behalf of Softwerx and Veronica, thank you very much today for attending today's webinar.